Hello YouTube, this is Vince White. I am an employment attorney. I am making my final video from New York for quite some time, I hope. And we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here posted 4 days ago from YouTube user New York Acoustics, who asked us, so if you win a lawsuit as a plaintiff and there's a standard 40% contingency fee in the retainer, how do attorney's fees work, say if there's a $100,000 settlement? Does the plaintiff's lawyer get the 40% contingency and the attorney's fees? Also, does the plaintiff get any piece of the attorney fees in New York? This is a case in New York Supreme Court based in New York City. Thanks. Okay, so great question, super thoughtful, really valuable for people. Let me specify this answer is going to be based in New York because I am more familiar with the laws of New York, and I'm also not allowed to answer as to the state laws of other states, although we do answer questions on this channel that pertain to the federal laws that pen through the EEOC in all 50 states. This, specifically as it was asked, will be answered as an example under New York law, and then there's going to be some variation state to state. So let's talk about first attorney's fees. What are they? How do they work? So let's say you go to trial and you win at trial. There's a good chance, depending on the laws you used and the savviness of your attorney, that on top of your win at trial, they can also apply for attorney's fees. This used to be called a lodestar application. It's now just kind of an attorney fee application. And it's complex because there's a lot that goes into it. They're going to be supplying affidavits, proving their hourly rate. They're going to be showing the hours they spent on the case, which they track very carefully, hopefully, for you. And trying to get the defendants to pay over and above the judgment against the defendants for discrimination or workplace sexual harassment, whatever it was, trying to get to pay the attorney's fees over and above that. Now, judges won't often grant everything that the plaintiff's attorneys put in as their hours, but they'll grant some portion. And we'll make up kind of a hypothetical to run through as an example, but that's the gist of what goes on with attorney's fees. Now, first question I always get about attorney's fees. What if I settle my case and I get attorney's fees in the settlement? Does my attorney take 40% of that? Yeah, you can't get attorney's fees in the settlement because that's not how settlements work. You settle your case for X amount of dollars, and your attorney takes 40% of X. And you can call any portion of that attorney's fees if you want, but that doesn't mean your attorney is going to say, oh, yeah, that's attorney's fees. They're still going to take, in this hypothetical from New York Acoustics, 40%. So, like, if you settle your case for $100,000, as per the hypothetical in New York Acoustics, that attorney is going to take $40,000 of the $100,000, 40%, right? And if you say, oh, well, I'm marking $20,000 of my $100,000 attorney's fees, realistically, your attorney's going to say, that's cool. That's a label. That's not real. I get 40% of every dollar I win for you because my percentage is 40% in this hypothetical. So I'm taking $40,000 of your $100,000, right? So in settlement, there are no attorney's fees. And this is just a constant source of aggravation for clients who are like, but I want to characterize it as attorney's fees. No, that's not a thing. Can't do that. No one's interested in that. Maybe you can get your attorney to agree to that, but they would have to be stupid to do that, right? Now let's go a little bit further. Let's say you won, as per the hypothetical, specifically this hypothetical that New York Acoustic puts out is that there's a $100,000 settlement. No, there's no attorney's fees in a settlement. Let's say there's a $100,000 judgment you won at court. And now the attorneys for the plaintiff are making an attorney fee application. Great. And let's say they do a terrible job on the attorney fee application, they win $10,000 attorney fees. I'm only saying this for the ease of math because I think it's going to be more demonstrative, okay? So, judgment for $100,000, 40% contingency, so attorneys are due 40% of the $100,000 they won for the plaintiff. And on top of that, the judge awards them only the dismal figure of $10,000 attorney's fees, which would be deeply insulting. Clearly, they would have had to mess up, or the judge would have total disregard for attorneys for this to be the case. Now, depending on how that firm works attorney's fees, they may say to you, shockingly, we get our $10,000 in attorney fees over and above our 40%. I have seen firms do this. I think that is unethical. I think that runs afoul of New York State law. So what our firm would instead do would be to say, and many firms, it's not just us, there's plenty of good firms out there, would be to say, hey, we should not double dip. We're taking 40% here. That is rather significant. And so if we're getting $10,000 in attorney's fees, we will reduce our 40% contingency, so our $40,000 in this hypothetical, by the $10,000 attorney's fees. So we'll take $30,000 of your $100,000, and then we'll take the additional in the attorney's fees straight from defendant. Right? Not every firm does that. And you want to firm up. Listen, is it likely your case will go to trial? No. It's not. It's very unlikely your case will go to trial. That being said, you should behave as if every case will go to trial, both because that gets you a better settlement in the long run, but also because it might. And you should have a complete understanding of what will happen if that eventuality occurs from the get-go. So you should firm up with whatever firm you're working with. Well, hey, how do you deal with attorney's fees? Is that in the retainer agreement? Like, this is a conversation to be had. This is an understanding that you should have in its totality at the time you retain a firm. And almost no one ever does. Like, I'll tell you this. There's a lot of people who will go through the entire process with me, and then, like, 3 weeks later, we'll try to say, oh, and I want to characterize of my $100,000 settlement, I want to characterize $90,000 as attorney's fees. Okay, we can call them rainbow farts if you want. It's not a thing. Like, it's, yes, I understand you're thinking being clever and you're trying to get out of your contingency arrangement, but that's simply not, as we say, a thing, right? And they'll look at you like you're crazy, like they think they've got the plot. They think they got the plan, right? They think this is a real thing they're engaged in. And it hasn't happened for years because we kind of just we're like, oh, okay, so you just don't understand this mechanic here, so we're going to be more explicit about it so we can educate you. But it was the thing that happened a lot early in my career. Like, when I was working for other firms, people would just be like, yeah, so I want all of my settlement as attorney's fees. Okay, but no. Not a thing, right? But I couldn't change that firm's, the firms, when you work for a firm, you don't get to change the retainer agreement. The retainer agreement is what it is. You can go to that firm and say, hey, I think your retainer agreement could use a little punching up. I think it could be a little clearer. I think there's some things that are not addressed in here. Maybe they'll make the change if they know it's good for them. Maybe they won't. Maybe, listen, there's definitely firms who believe keeping it simple is beneficial. We don't. I mean, we keep it fairly simple, but I think it makes sense to have a lot of explicit things spelled out because I don't like surprises for my clients, right? And that's why I think you should know exactly how attorney's fees will be handled with whatever firm you're working with, right? Attorney's fees could end up being millions of dollars. Objectively, they can. That's rare, but it happens. And attorney's fees are routinely hundreds of thousands of dollars, right? Like, it's not unlikely for a case that goes to trial that the plaintiffs might be seeking $300,000, $400,000, $500,000 in attorney's fees. That's somewhat commonplace in our industry, right? And that's also the other thing people don't fully understand, right? The amount of time and effort and resources plaintiff side firms pour into a case is not always clear to plaintiffs, right? They're like, oh, it's just words. You're just talking. It's nothing. No, literally, the equivalent of $500,000 of billable time has been poured into this case trying to help you. That's why we're not we're not super excited about you trying to steal the contingency, right? Like it's why there's systems in place to make sure that's not going to go very well for you, right? Because we've invested in you to the tune of hundreds of thousands of dollars and hundreds upon hundreds of attorney hours. So I love that you're asking this question, New York Acoustics. It's a very insightful question. No, the plaintiff will almost never get a piece of the attorney's fees unless there's an agreement otherwise, right? If you put that in your retainer that you want a piece of the attorney's fees, listen, and a firm agrees to that, then that's the deal, right? That could certainly be a deal that you reach. With us, I guess they do get a piece because we reduce our contingency by the attorney's fees. So, I mean, realistically speaking, I guess what I'm saying is the way we handle it, in reality, our clients receive the benefit of almost 100% of the attorney's fees. In that, one for one, if we receive 10,000 attorney's fees, we reduce our contingency award by 10,000. So I would make the argument, I guess, that our clients achieve 100% of the attorney's fees as money in their pocket. It's just not direct. We reduce our contingent percentage by what we receive in attorney's fees. But just specify that. Make sure you're aware of how your firm that you're specifically working with handles this, right? And I feel like there's going to be follow-up questions here. This is a very complex topic. I'm going to track the comments in this video, as I do in all the videos. And if you have follow-up questions, I will try to create you the answers for that. There's a lot of people over the course of my career who did not fully understand how this mechanic works in our field. Frankly, even attorneys. I've seen attorneys try to do lodestar applications, attorney fee applications, and just not understanding. And I get it. I get why you might not. If you're like a trial attorney in a field with, without attorney's fees, and you come to our field and you try a case and you get all excited because you won, and somebody's like, well, put in your attorney fee application. That attorney might be like, see the what now? Huh? What? I get more money? What for? Right? Just a cool thing that happens in our industry. It's one of the many upsides of our industry. Anyways, comment down below. I will check the comments. If this video was helpful, like, subscribe, comment below. That all helps me to help more people just like you. And remember, almost everybody works. Not everybody wins. Got to be smart out there.